To discuss the connection between AI and intellectual property, we are delighted to welcome Keith Kupferschmid, CEO of Copyright Alliance, and Andrei Iancu, partner at Sullivan and Cromwell. The conversation will be moderated by Rama Elluru, Senior Director for Governance and Intellectual Property at SCSP.
Good morning, everyone. Welcome to today's panel, AI and IP, Unleashing American Innovation, one of my favorite topics. I'm Rama Elluru, Senior Director of AI Governance and Intellectual Property at SCSP. I'll be your moderator for this very important conversation. Let me introduce you to our esteemed panel. Andrei Iancu is co-head of IP and technology litigation at Sullivan and Cromwell, as well as the former director of the United States Patent and Trademark Office. We also have Keith Kupferschmid. This is the CEO of the Copyright Alliance, which represents the copyright interests of over 200 million creators and over 1,500 organizations in the United States. Our discussion today will focus on AI and its impact on the IP regime, including patents as well as copyrights. Keith, can we start with the basics? What is a copyright, and what does the Copyright Office do?
Okay, thank you. First of all, thank you very much for having me here to speak on these issues. So copyright actually goes way, way, way back, right? Its origins come actually from the U.S. Constitution itself, right? And the founding fathers believed at that point that the best way to incentivize people to create new works of authorship and artistry and what have you, is to basically incentivize them by giving them a property right. And that property right is copyright. And copyright exists in many different exclusive rights that are granted to a copyright owner. And there are also exceptions and limitations of those exclusive rights, one of which is called fair use, and I'm sure we will talk about considerably going forward. The Copyright Office is the agency, the federal agency, that administers the copyright law, and in particular, copyright registration and recordation, and importantly, also gives guidance to other federal agencies, the public, and especially Congress. Now, one thing very important to note is the Copyright Office is actually located in the legislative branch, in the Library of Congress. So it's not considered to be a federal agency. I was just at a hearing the other day where the Copyright Office was referred to as a unicorn because of its hybrid situation where it's both a little bit executive branch functions and a little bit legislative branch functions. And most recently, in terms of AI, the Copyright Office was asked by Congress to put together a study on AI and copyright and how the two relate to one another. And there have been 3 reports that have come out already, and we're awaiting a 4th report, actually. The first report was on digital replicas, the second report was on copyrightability, and the 3rd report, which just came out, which is on AI training and licensing and fair use and those issues. And the last report that is still to come out is on the output side, is about liability and infringement on the output side.
Thank you. Former Director Iancu, same question to you to set the stage. Could you briefly explain what a patent is, how it relates to the innovation ecosystem?
Yes, thanks, Rama, and great to be with everybody. Great to be back at this conference once again. Just to back up a little bit, there are multiple forms of intellectual property. Keith mentioned copyrights. That is one form. Another form of intellectual property are patents. Patents generally protect technological innovations, or as the Constitution says, the useful arts, practical applications, whereas copyrights are focused more on the fine arts, writings, music, paintings, and the like. Another form of intellectual property is trademarks, and then we also have trade secrets. Those are the 4 major categories of intellectual property. There are a few others, more minor types of rights, such as data protection for FDA studies and the like for drugs, but the 4 major ones are the ones that we've mentioned. While copyrights are being administered by the Copyright Office, as Keith mentioned, that's in the legislative branch, patents and trademarks are administered in the Patent and Trademark Office. That is a government agency within the Department of Commerce in the administration.
Thank you. Keith, you mentioned that first report that the Copyright Office issued about digital replicas. These days, video, audio, and image generation models are getting much better, have increased capabilities. What are the risks with fraud and deepfakes, likenesses created with AI, and how has Congress responded to these concerns?
Yeah, I mean, that's a great question, and we talked about the different forms of intellectual property, and this issue about digital replicas and deep fakes and things like that isn't necessarily purely a copyright issue. There's certainly copyright elements to that, but it's not purely a copyright issue. But it is a very, very important issue, and it's one that Congress has chosen to take on. And there's been a bill introduced that has bicameral, bipartisan support in Congress. It's called the No Fakes Act. And the No Fakes Act, not only does it have support, tremendous support within Congress by both sides of the aisle, but it also has tremendous support by industry itself. You'll see companies like OpenAI, IBM on the tech side. You see Motion Picture Association, the Recording Industry Association. They all support this. We have unions like SAG-AFTRA who are supportive, and a long, long list of other groups that are supportive. So this legislation, you can never predict whether legislation is going to sail through or pass or not, but I would think that this particular bill has a great shot. And what the idea behind this bill is that it would protect against misuse of somebody's visual likeness or their voice, right? As in the examples, for instance, you gave. And it would give that person the power to, for instance, to send a notice to an ISP to say, hey, wait a minute, this is my image, this is my voice, take this down, or to be able to bring a lawsuit. Now, the last thing I'll say about this is that there are protections in the bill, and that's why it's got such wide support, I think, to protect against First Amendment uses and things like that, like satire and parody and commentary and criticisms and scholarship, and I'm probably leaving out a bunch of other uses, but there are those safeguards in the bill. So it's a very, very balanced approach, a very balanced bill, one that a lot of our members of the Copyright Alliance certainly are very supportive of.
And former Director Iancu, Congress is also considering other pieces of legislation related to intellectual property. Could you briefly highlight the main proposals? And in your opinion, do they adequately address the challenges posed by AI?
Well, so first of all, just again, to step back a little bit, the founders, when they put intellectual property rights in the Constitution, Article 1, Section 8, Clause 8, where they say that Congress can give authors and inventors their respective rights, exclusive rights to their respective writings and discoveries, they focused on human beings, authors, and inventors. Innovation, creativity is a uniquely human activity, and this is where we run into the issues posed by AI that I'm sure, Rama, you're going to get into a bit later, but I just want to set the stage that the founders understood the uniqueness of the human contributions and human creativity, and the Supreme Court has recognized all along from the beginning till now that authors and inventors have to be human beings. So the question that becomes, how do you address creativity that is made perhaps by AI or the use of AI to a significant extent? And do you grant patents, do you grant copyrights, and the like? So these are very complicated issues, and they manifest themselves in different ways. One particular way in the patent arena is a question of whether machine learning technologies, whether various types of advanced algorithms are patentable. To begin with, are they within the patent code at all? Are they covered by the patent code? And that is, in the statutes, that is 35 U.S.C. Section 101. And one of the bills that addresses this issue, to Rama's question, is PERA, Patent Eligibility Restoration Act, which addresses issues of patentability, what is within and not within the patent system, and it would clarify whether various types of algorithms are within the patent system. It also is broader than that. It goes to diagnostic tests and other things like that. The bill has been introduced. It's bicameral and bipartisan, and we will see whether it moves. A second bill that is out there right now is called the Restore Act. Again, the Constitution provides for exclusive rights for patents and copyrights, but for patents in this case. And since the Supreme Court's decision about 20 years ago, almost, in the eBay case, injunctions and therefore the right to exclude have become much more difficult to obtain. And the Restore Act, again, bipartisan, bicameral, would make it a presumption that if there is a finding of patent infringement, there is a presumption that an injunction should issue in that case. And finally, another major patent bill is called the Prevail Act. It deals with a particular branch of the US Patent Office called the PTAB, the Patent Trials and Appeals Board. It amends the America Invents Act of 2012, and it just modernizes that a little bit based on the last 10, 15 years of experience. Again, bipartisan, bicameral has been introduced. That bill actually went through committee in the last Congress, and it was voted positively out of committee, and we'll see if it happens again in this Congress.
Thank you for that overview. One of the critical issues when we talk about the AI impacts on intellectual property is the protections that are afforded output of AI models. With respect to copyrightability, how is the Copyright Office guidance say on that, and how do courts determine the copyrightability of a creation that's a result of both human and AI creativity?
Yeah, I mean, that's a terrific question. Excuse me. Andrei talked a little bit about what the Constitution requires, which is, human creativity or human inventorship, right? And so that's a big part of it. And so think of copyrightability as sort of a scale. On one end, you've got something completely created by a human being. That's clearly going to be protected by copyright. On the other end, you've got something wholly created by AI. That's clearly not going to be protected by copyright. The problem is in the gray area, right? It's not on those two extremes. It's in the gray area. And when you use AI, how much is too much? In other words, how much pushes you more toward this side of the spectrum than the other side of the spectrum? For instance, let's say you're writing a book or something, and you just ask the AI to fix your grammar or something like that. That's clearly going to be closer to the spectrum of a human creation and is going to be protectable. But you might have the flip side and say, okay, AI, I want you to write a short story for me, and it generates a short story and puts it out, and then you go in and change the names or something. That's going to be more to this spectrum. And there's no clear dividing line. The Copyright Office has asked, as it's typical to do in other areas, that when you are registering your copyrighted work, that you disclaim anything that was generated or generated by AI. And so whenever somebody registers a copyright, they need to do that. And the Copyright Office has issued, I think, don't quote me on this, but I think it's been about 1,000 different copyright registration certificates at this point, where it involves some level of AI or not. And deciphering sort of how much is too much and is obviously a very, very difficult issue.
And on the patent side, how is the patentability of inventions that are the result of both human and AI ingenuity handled? And importantly, do you see any kind of inconsistencies between the approach taken on the copyright side because of the bifurcation?
There is some consistency in what the two offices have done. Most of this work was done in the last administration, and the Patent Office, similar to what Keith has described from the Copyright Office, at this confluence of human innovation together with AI technology, creating an invention where both have contributed. The office has issued guidance, and tries to draw some lines as to whether it is patentable or not. Again, the office would say if it's fully done by the machine, it would be not patentable. If it's fully done by the human beings, would be patentable. And to the extent there is significant, they would say, if there are significant human contributions, then it's patentable. Where the line is drawn is going to take a long time to figure out precisely, because it's going to depend on a lot of patents being issued and then challenged in court. I will say, Rama, if you ask my view, which you haven't, but I'll offer it anyway.
Thank you.
You know, I actually think that the guidance, both from the Patent Office and from the Copyright Office, is somewhat misguided in this space. People are freaking out about AI, unlike many other technologies that we have out there. Human beings have been working with tools and machines for a very long time, and they are incrementally getting more powerful and better machines and more useful for human beings. But ultimately, they're all just tools for human beings to use. And it's very hard to draw the line between what is an invention assisted by AI versus an invention assisted by a very powerful computer that somehow is not AI. In the end, there are human beings that have designed the AI. There are human beings that have trained the AI. There are human beings that have put the prompts into the AI to create the artwork or the technological invention. In the end, it's always, at least until we get to the point of singularity, which I don't think anybody here is quite there yet, at least until then, human beings are always involved, and the AI is always responsive to the human beings. That's my personal view anyway. And I think we need to take a step back and not treat AI very differently from a protectability point of view. The use of AI treated very differently from a protectability point of view, and simply ask the question, in the end, is the creation, is the artwork, or is the invention, is it innovative enough over what has come before it? Is it creative enough to deserve copyright or patent protection? To me, that's the question that should be asked under existing law that doesn't need modification. And just very quickly, there's a practical reason for all of this. Not just textual, not just statutory or historical. There's a very practical reason. In the end, intellectual property is the currency of innovation. It's the currency of creativity. It enables bringing these creations to the market. It enables investment in the creations in the first place. And if you don't have protectability, if we get all twisted up by the fear of AI or something like that, and the result is no protection, then it will be much more difficult to invest in that new technology and much more difficult to bring it to market and do the testing at scale that's required. So from a practical aspect as well, I think we need to take a step back and just understand that AI is a tool, a very advanced tool, but a tool nonetheless.
And let me just add to that if I can, because I forgot to mention one thing. I mean, Andrei makes a lot of really, really good points there. But I forgot to mention the Copyright Office itself did issue some guidance back in the spring of last year. When it issued the guidance, they knew it was sort of the first step. They weren't going to get everything right necessarily. And from what we understand, that they are going to be revising that guidance at some point in the future. That remains to be seen exactly when they're going to issue the revised guidance. But this is very much, obviously, these issues are very much a moving target, and we're all trying to understand kind of how to deal with them in the context of IP generally.
Moving on a little bit, a key debate is whether training AI models using copyrighted work should require permission or compensation to creators, or whether it should fall under an exception called fair use. Keith, what are the arguments on either side of let's protect content creators, let's protect innovation?
Yeah, I mean, first of all, I should say, you'd say like, okay, on this side you have innovation, and on this side you have the AI companies, whatever, and you need to make some kind of dividing line. There does not need to be, right? I mean, we live in a country where the AI industry is dominant and the IP industries are dominant, and there is absolutely no reason we can't have a win-win. There's no reason both of those cannot continue to dominate, but both of those industries cannot continue to dominate, right? So the issue you bring up about AI training is an issue that is not just the key issue, but the issue, right? The biggest issue in AI and copyright. And it is an issue that is at the heart of about 40 pending cases across the country. And the courts eventually will decide those cases. And so on one side, what you have is, it basically comes down to, is use of copyrighted works for AI training, is that considered to be fair use?
And maybe explain what fair use is, and bonus points if you can do it with respect to AI.
Yeah. So with fair use is basically this 4-factor test. So it's not just some black letter law in there that's very clearly applied. It's a 4-step balancing test. And what the courts will do is look at each of the different factors of the fair use test, and they'll balance them. They'll look, okay, does this factor weigh in favor of the AI company, or does it weigh in favor of the copyright owner? And they'll do that through all the 4 factors, and at the end of the day, the court will make a decision. This isn't just about AI. This has been going on for years and years, 100 years or so, right? With this fair use doctrine. And now, the only difference is, frankly, is that we are applying it to a new type of technology, right? And so courts are approaching this for the first time. There's been one court, the Thomson Reuters versus Ross case, that did deal with this, and they concluded that it was not fair use. Now, in that case, did not involve generative AI. It was just artificial intelligence, not generative artificial intelligence. So it is a little bit different, but there are a lot of other cases where we're going to hear the courts chime in here and say, is this fair use or is this not? Now, I'm not going to go through all 4 factors here. We will clearly go into lunchtime if I do that. But the big takeaway, I think, is that fair use is decided on a case-by-case basis. There's no categorical fair use. There's no such thing as categorical fair use. What you have to do is look at each particular use, all the facts in that case, and then apply the fair use doctrine. So in some instances, use of copyrighted works for AI training purposes may in fact be a fair use. But in many other instances, it's not going to be. And in fact, in many of the cases pending before the courts right now, I think the likely outcome in most, if not all of those cases, it's probably not going to be considered to be fair use for various reasons. One of the big implications here, or considerations, is the AI training competing in the market with the copyrighted work that's being used to train? And so let me give an example. Let's say you have an AI system that copies all of Prince's works out there, right, to produce a Prince-like work. Okay, maybe it is substantially similar, okay, but even if it isn't substantially similar, the purposes are the same. The purposes of music is the same whether it's AI-generated music or whether it is the creator, like Prince's music. It's to whatever you listen to music for, whether it's to enjoyment, for education, for, to change your mood, whatever the case may be. So because of that, I think, especially in the music case, I think it's going to be very, very difficult to prove that there's fair use. But we'll have to see how the cases come down. This is going to be a very, very long process. First, we're going to start to get some district court cases, and then no doubt those decisions will be appealed. So we're still probably, I think, several, or at least a couple years away from some final decisions, but we'll get some idea. And in the meantime, Congress, there's no legislation on this. You heard Andrei talk about a lot of different patent bills, but there's no legislation having to do with AI training, and rightfully so. Both sides, if you will, the AI companies and the copyright owners, are looking toward the courts to basically appropriately apply the fair use doctrine. I think if they don't, then maybe you'll see some legislation, but right now there's nothing pending.
And do you have any thoughts on whether licensing frameworks will help?
Oh, I mean, that's the solution, period. I mean, that's what we've seen across the board throughout the history of copyright, is licensing will work, and we are seeing it work right now. We are seeing a lot of AI companies licensing works directly from copyright owners, and where it might be too difficult or inefficient to try to license, we're seeing these collective rights organizations that represent many different individual creators. We're seeing them, those small businesses created to represent all these individual creators, so the AI companies can sort of have a one-stop shop, right? They can go to this one entity and get licenses for many different authors and artists and musicians and so on and so forth. So licensing is absolutely the solution, and it's just, I think we're starting to see that take a foothold right now, and it's only with each passing day it seems to increase.
Former Director Iancu, that debate about protecting innovation and protecting inventors also takes place on the patent side. Some influential voices argue that patents are no longer necessary or might even hinder innovation. Do you have any thoughts on that argument?
Well, for the folks who think patents are not necessary, they should not apply for patents and not get them. For those who think that they are necessary for their own businesses and for their own obtaining investment and the like and licensing, then for them, they should get patents. Patents are not mandatory, therefore. So, but you know, to tack on a little bit to what Keith mentioned about fair use, there's a policy argument on top of this issue. The policy argument effectively says, look, if the United States is going to compete with China or otherwise in the AI space, you know, it needs various AI companies will need access to the data to train their models. And in the United States, at least, the data is very fragmented between various creators. And they just simply need access to that so that they can train the models and grow the models and compete internationally at scale. But the answer to that is not effectively stealing IP. The answer to competing with China, who is stealing IP, is not to steal our own IP. And the answer really is, as Keith mentioned, licensing. There's nothing wrong with the concept that you need access to a broad-based database set. And the way to do that is to license it either bilaterally from the creator to the user, or through coalitions of smaller creators and the like. And there are plenty of models like this that we have seen in the past, with music licensing, for example, and the like. And the same thing is true on the patent side as well. So I think there are models out there that can work and should work, and it's a win-win. We can create systems where folks have access to the data they need, but the creators also get compensated and retain rights to their intellectual property.
Thank you. And you mentioned competition. AI is a global technology. Different countries have different approaches to how they're going to handle protections. What are your thoughts on whether we need collaboration with respect to copyright laws to preserve the U.S. domestic ecosystem?
Yeah, I mean, we definitely need to collaborate, right? AI is not going to be just particular to the United States. We see other countries throughout the globe taking on these very same issues and reaching sometimes very different results, right? And that makes it difficult for everyone. It makes it difficult for copyright owners. It makes it difficult for the AI companies to try to adhere to all these different laws. And so typically, the United States has led the way in intellectual property. And there's no reason that the United States should not continue doing that. And basically taking its intellectual property policies here in the United States and, as Andrei mentioned, sort of not lowering our standards, but making sure other countries come up to our level and protect IP and reach our standards. That's essential going forward.
Same question to you. Do you think we need collaboration on the patent side to ensure that U.S. companies have access to global markets?
Yeah, absolutely. I think collaboration is critically needed in all areas of technology. I think it's good for the United States. The United States has a significant trade surplus when it comes to intellectual property, and it's not even close. And American companies will benefit if the standards worldwide on intellectual property protection are high, matching ours here in the United States, and gives them comfort and security that they can collaborate with foreign entities while their intellectual property remains protected in those lands. And the only way to collaborate in a free market system is to have a robust rule of law. The way to collaborate is to have intellectual property laws that people can rely on, companies can rely on, and the investors, both domestic and overseas, can rely on. That way, information can be exchanged and collaboration flourishes.
And we could talk about this all morning, but we're at time, so I want to close on one last reflection. How do you think the copyright regime is going to look 10, 20 years from now?
Oh, just a small little question to end here. I mean, honestly, it's anybody's guess at this point. We're going to have to see how the courts take on these issues going forward, and then honestly, the debate may move over to the to Congress. Hopefully, Noble will short circuit that discussion. But honestly, I'd be a fool to kind of try to predict where technology is leading us and where the law is going to morph and change over the coming months and coming years.
Director Iancu.
Well, as Yogi Berra said, predictions are difficult, especially about the future. So, as Keith said, very difficult to predict, very fast-moving technology and very fast changing of the legal system. Having said that, intellectual property has been a bedrock of the United States economy from its founding. The word right is mentioned in the Constitution only once, believe it or not, in the body of the Constitution, putting aside the Bill of Rights, only once, and it's in the intellectual property clause. That is where the word right is mentioned, and it gives authors and inventors their exclusive right to their respective writings and discoveries. And I believe that it's done us really well for the last 250 years. I think, on balance, when the dust settles after we understand fully the impact of this new technology, AI and quantum and all these new technologies, I think in the end, intellectual property will still remain robust and enable future innovation, future creativity, and bringing that innovation and creativity to the market so everybody has access to it.
Thank you. Please help me show our appreciation for our speakers, Keith Kupferschmidt, CEO of Copyright Alliance, and former director Andrei Iancu, partner at Sullivan Cromwell.